9. Good morning, ladies and gentlemen. This is the Governmental Affairs Subcommittee on General Government. Welcome to our meeting. Before we get started, we're going to open with prayer. Representative Bernal, if you would open us in prayer.
Thank you, Madam Chair. Let's all bow our heads. Dear Heavenly Father, thank you for bringing us here safely this morning. We pray that all that we will do will be pleasing to you during our subcommittee meeting, and we thank you for all your many blessings. Amen.
Amen. Thank you. We have several measures to go over this morning. We'll start with House Bill 92. Representative Gamble, if you'll come to the podium. Thank you.
Well, good morning, Madam Chair, members of the committee. First of all, happy Friday. Wow, I just drove in this morning and decompressed and got up here and present this bill, but glad to be with y'all today. House Bill 92 is something I'm trying to do that I think will help our constituents that are very interested and involved in genealogy. And so this is what I feel like is a very bipartisan bill. This is crosses all kinds of boundaries and geographies and locations. I've heard from a lot of people about this, but basically last year there was a bill that we passed that was what we refer to a lot as a code cleanup, title cleanup, and in it the provision that affects us today was addressed, where it increased the number of years for vital records, birth certificates and death certificates and whatnot. And basically what you have before you is that we would go back to the previous years that had been specified under the law prior to the change last year. And I've met with the department on that, and I know that they have expressed some concerns, particularly around the birth certificates and not the death certificates, and that their conversation with me was around the fact that people are living longer now, and that there was such sensitive information in a birth certificate that it was best to have it at 125. And Madam Chair, I don't know if we take testimony in subcommittee today, but I do have two very distinguished guests with me that are directly impacted by the change we made last year. And I would like to call on Miss Elizabeth Olson and Emma Hamilton to share at least a little bit of perspective on how this change has impacted our constituents' ability to gain access to these records for the various things that are done with them. So if y'all would come forward and speak briefly to this legislation.
Ma'am, we're gonna turn this mic on so you don't have to go so far. They're coming to fix it for you right now. What's the number? 21. Thank you.
Okay.
Please go right ahead.
Good morning. And I thank the committee for allowing us to give our thoughts on this bill, HB 92. I speak for the African American community, and I'll tell you how it's facilitated us in kind of documenting our history. As you know, the history of slavery, there's very little about my people. Like my great-grandfather, I couldn't tell you who he is. However, with these documents being open and available to us, especially at the National Archive, I was able to go through that document. I could look at my county. I could look at Miller County, Baker County, Early County, which is where my ancestors were enslaved. And by being able to do that, I was able to document not only my great-great-grandfather who was enslaved in Baker County, but also several collateral other relatives. I was able to build a community for my ancestors. I was able to, being able to do that, I located about 10 ancestors that I never would have known about. And so one thing about it, at the vital records, if it remains there, I would never have been able to do that. I would have to have known who it was. You have to have a name when you go to vital records. But when these records are open and they're made to the public at the National Archives, I can look at communities. And that's one thing that if this happens, it'll prohibit that And to make things 100 years, I'm an old person. If I have to wait that long, I may never have found this. Also, just as a side note, if we talk about things being open to the public and being able to find parents, the National Census, the United States Census, it's open in 72 years. Anybody here born 1940 or before, I can probably tell you all about yourself, your parents, and where you lived and what you did and where you ate. So that's my offering here today.
Thank you very much for sharing that with us.
And if you could speak to how that change from last year has directly impacted the ability to gain access to these records.
Good morning. The biggest impact on
Can you
this,
introduce yourself?
I'm Elizabeth Olson. I'm from
Thank you.
Suwanee, Georgia. I'm a professional genealogist and a historical researcher. And I work on a lot of large projects. The change in these statutes were addressed as being protection, identity theft protection for senior citizens, and as a convenience measure that would make it easier for seniors to order these certificates from the comfort of their home. Prior to this statutes being changed, you could obtain a copy of these open certificates for 30 cents from the Georgia Archives, or you could download it from the comfort of your home for free. Now we will have to pay $38 a copy for a document. A project I worked on last year, I looked at probably between 300 and 500 death certificates. It would be cost prohibitive for anyone to do the project. And I do military repatriation projects for the U.S. Army where remains are discovered. And my job is to find the surviving relatives of these men and get these men repatriated to the U.S. And entry on these vital records might be the only link I have to finding their living, surviving relatives. In Georgia, we didn't have vital records until 1919. That's when they first started recording, and then it took them a while to get it going. And so 2020 was the first year that birth records would have been opened in Georgia. They weren't open, they weren't transferred, and they weren't opened. And so the idea that we have identity theft in these birth records is just based on hypothetical possibilities. There hasn't been any identity theft in these records. And for many research communities, these would be the only records that you're going to find that link to the past. If the death records are closed, then we lose access to 25 years of records that we've had access to for some time. And it hampers my ability. It also prohibits research for historians, scholars, academics, medical researchers, criminal investigations, and that list just goes on and on. Closing these records is just short-sighted when you're talking about a real small percentage of the population and what is actually done with these records. Last year, the day that they voted to move SB 372 out of committee to be voted on, they gave an award to a young woman who had used these records to track prostate cancer in African-American men over a period of years. So the same day that they gave her this award, the ability to do that research was taken away. So it's a very important thing, not just for genealogists, but for anybody that's doing important work in history for these records to be open and available at the Georgia Archives. We have to get them from the Vital Records Office. You can't pay $38 per document to do these projects.
Thank you very much. Thank you. We have number 9. Do you wish to ask a question?
Oh, thank you.
Thank you.
Madam Chair. I just had one question. Is it the $38? That's how it is already in the legislation, and then the change was, what will the change do?
In the bill, it said $25.
Mm-hmm.
However, you can at this time, because of the can only order online. If you walk into a vital records office, it's supposed to be $25. If you order online, there's the $25 fee. Then there's an $8 ordering fee. Then if you use a credit card, there's a credit card surcharge, and you have to order by credit card, which we're one of the few states that has that requirement that you have to order by credit card. Most take personal checks or money orders. So I ordered a birth certificate in October. It was $38, and it took 6 weeks to get it.
Okay, thank you.
Does anyone else on the committee have a question for the author? Do you have any closing remarks?
No, I just appreciate your consideration and appreciate both of you taking your time to be here today, especially on a rainy Friday. But thank you.
Do I hear a motion? Thank you. And got a motion and a second. All in favor, say aye.
Aye.
The ayes, let's see, online.
Shane's aye.
Williams, aye.
Okay. It appears the ayes have it. Your bill will move forward.
Thank
We'll
you.
have a meeting Monday.
Thank you.
You'll get notice. Thank you. Thank you very much. Let's see, our next bill will be House Bill 468. Representative, let's see here. I'm sorry, 465. 465. There we go.
Are you ready?
We're all ready when you are.
Thank you, Madam Chair, members of the committee. I present House Bill 465. It's LC 364652. This is a bill that says alarm contractors shall not be responsible for false alarm fines unless the alarm system contractor was actually responsible for the false alarm. So what we have municipalities kind of across the country who have begun fining the alarm system contractors, the alarm companies, for their users' false alarms. And false alarms are definitely a problem throughout, I'm sure, every jurisdiction. I think 80% of the false alarms are done by 20% of the people. And but the reality is that this isn't the cities and municipalities that are doing this are really doing this in the interest of expediency. They've enacted these programs to find the alarm system, to find the alarm companies as opposed to the customer. And it really goes against the whole fine, the reason for the fine. The reason for the fine is a punitive perspective in order to discourage you from continuing to have false alarms. That impacts public safety. And so when you're fining the alarm companies, you're not actually punishing the customer themselves. The alarm companies then have to try to recoup from the customer. And a lot of times they don't. Alarm systems, I think mine is $19.99 a month. And then you get a fine up to $400 in Georgia. The alarm, it's really easy for me to cancel my subscription and go somewhere else. So it's a heavy load really on the alarm companies themselves. The actual fine does not actually discourage false alarms from the users who have the alarm systems who are responsible for the false alarm, but rather it's trying to punish alarm companies who they've done nothing wrong. There's a contract between an alarm company and the consumer. Says if I call you, my alarm goes off, I call you twice, you don't answer, there's a problem, we're going to dispatch police, or we're going to let the police know. So that's what this bill does. It just prohibits that. It requires the fines to then go to the actual user of the system and not the alarm companies. Happy to answer any questions. I think we have some speakers today to the bill too.
Thank you. Let's see, does anyone on the committee have any questions for the author? Yes, Representative Renal.
Thank you. I have ADT, and I know that if our alarm goes off and they have to come out more than one time, then the police department issues a ticket. Is this the same thing, or is this?
It is, but what's happening is the police department or city, instead of issuing you a ticket because it's your alarm that or they're issuing ADT the ticket.
The ticket, they tell us the ticket that will come to us, not the alarm
Yeah,
company.
so that's typically the process, but
Okay.
there are some municipalities in Georgia and then around the country
Mhm.
who are actually trying to find ADT instead of you. And so what's happening is if I'm an alarm company, I'm going to say I'm not going to offer alarms in your city,
Mhm.
because why would I take the liability and why would I take those fees when really it's my user's problem? And what we do have a thing, there's a caveat in the bill that says if I'm an alarm company and I actually install this alarm incorrectly and I'm getting false alarms, not because the user didn't answer the phone calls, but because there's a faulty alarm, then the alarm company is responsible. The alarm system contractor who installed it is responsible. But if I'm not answering my phone, if I'm a business, and businesses, I imagine this happens to businesses more often, just because there's someone who works there and maybe they no longer work there. The alarm system they didn't get updated of who the contact person is,
Mhm.
but middle of the night, and all of a sudden police are dispatched. That's a public safety problem, but let's discourage that by punishing the business or the residential customer, not the alarm company, because they're going to get out of the business. The alarm's going to go off, the noise is going to be made, and the police are never going to know. Because why would I take that liability? Because, there's a lot of false alarms.
All right, thank you.
Thank you. Are there any other questions? Anyone on Zoom that has a question? Okay, we do have several people to speak to the bill. Go ahead, Representative Sands, you have a question?
Thank you, Madam Chair. Can you hear me?
Yes.
Representative Gull, just to be clear, you would be codifying what the grand majority of Georgia cities currently do. Is that correct?
That's correct.
In this bill? All right, thank you.
Yes.
Thank you. All right, we do have some folks to speak to the bill. Let's see, first on our list is John Loud. Thank you. Please come to the podium. Introduce yourself and who you are, where you're from.
Good morning, Madam Chair and representatives. Thank you so much for the service you all do for our great state of Georgia. My name is John Loud. I'm president of Loud Security Systems based out of Kennesaw, Georgia. I also have served as president for GELSA, which is our state alarm association, the Georgia Electronic Life Safety and Systems Association, for 3 years. I currently serve as vice president of ESA, which is our Electronic Security Association on the national level. And I'm currently chairman of the Cobb County Chamber of Commerce for 2020 and 2021. So in that role, I interact with about 2,600 businesses of all different various sizes. The bill that's brought before you, House Bill 465, is really about as many of the police jurisdictions that we've worked with for more than a decade, in the partnership with the alarm industry, with the Georgia Association Chiefs of Police, GACP, we created a model ordinance that began back in 2003. And this model ordinance was developed with law enforcement from sheriffs, chiefs, and others over a multitude of years that then became a partnership that whenever any local city or county wanted to adopt some sort of an ordinance to kind of manage the false alarm issue, while our industry has been striving to find ways to solve the issue at the same time, it's been a very cooperative effort. The model ordinance was finalized about the year 2005. And I'm going to give you an example from Cobb's perspective. In the year 2007 and 2008, there was a long study done in Cobb, which had about 46,000 calls of service for false alarms, of which we knew clearly 95% of those were false. So we all hunkered down for about a 2-year process to identify that model that could reduce that. That model was passed in Cobb in 2009 and went into effect in 2009. They went from 46,000 calls of service, and by the year 2014, they had reduced that to 15,000 calls of service. So that is 46,000 to 15,000, which is a dramatic, and I assure you, as an alarm company installing for the last 25 years, we significantly increased the amount of installations in Cobb and most throughout. But the individual responsibility, mostly as Representative Gullidge mentioned, is businesses that are having this false alarm issue. It's training the personnel and the managers to come in and utilize the system properly. So while we've had the reduction, to have the individual, and the police departments will always tell you that if you find the individual responsible for the actions, they're going to be a change of behavior. If you're finding somebody else, that change of behavior is never going to occur. They're not going to update their system or get educated on this system on how to use it. And just to your point, typically 50 plus jurisdictions right now have model ordinances throughout the state of Georgia. Everybody gets to vary their own. Everybody has their own choice as to what's the right. These are just recommendations from the alarm industry and GACP to say, here's what's effectively worked. We go in before the mayors, the county commissioners to kind of guide them and give them historical aspects as to what's worked in other areas. Across the United States, there are 7. We actually would be state number 7 if this was passed. And it's also before the legislature in Mississippi and South Carolina. And it's really to try to keep it from a business perspective. And I'll use my personal scenario. I drive a Ford. I went to a Ford dealership and bought a car. If I go down the road and start speeding and I get a citation, should that citation go to the dealership I bought it from, or should the citation go to me? And that's kind of the real specific analogy of that. The other part is when a jurisdiction, there's been very few that have done this, but when they've done it, I will tell you for myself and many of the other alarm industry folks, it is not really worth doing business in that area because the fines, as he shared, and when you're paying a $20 monthly fee, but the fines are $400 and $500, and to go collect those is about impossible. So businesses then choose to shut down. Now, there are other models around the United States that people go to non-dispatch. But most elected officials that say, hey, if we can find the alarm company, don't want to go to non-dispatch because that would limit, that would put them in a bad situation not having the police do that. But with that, I'll take any questions. Thank you for the opportunity.
Let's see, who's at number 14?
That's me,
Thank you.
Madam Chair. Did you name your business after your name, or did you change your name to name your business? I've heard your commercials.
I was
Very
born
effective.
loud. I've always been loud. It just happened to, I was a flight attendant with
So
Delta
you were
Airlines.
born with that name.
I was born loud. Yes, sir. Yes, sir.
Thank you. That was the only question I had, Madam Chair. Thank you.
Thank you. All right, I don't see any other questions. Is there anyone else? Okay, thank you very much for your testimony. We have Michael McPherson.
Thank you, Madam Chair. Can you hear me?
Yes, he's.
All right. Well, thank you, and thank the members of the committee for your time this morning. Alarm companies sell security systems to their customers, yet rely on police departments and local emergency systems as part of their model. The alarm companies are the ones making the call to the emergency system. There is a minimum due diligence required in the code. Alarm companies are required by the official code of Georgia, Title 35-1-9, to make 2 reasonable attempts to verify that a burglar alarm is valid before calling the police or the emergency system. Now, some systems, it's my understanding that some systems are outdated and make calls automatically, which is problematic because those would not be following the code. The city of Brookhaven and the city of Sandy Springs prefer to enforce Title 35 rather than fine customers of alarm companies for false alarms. The amount of false alarms clogging both city systems fell dramatically after the institution of their ordinances. The time value saved can be measured in police hours. The value of lives saved by police officers responding to real emergencies cannot be measured. Both cities have provided means to challenge false alarm penalties, though once a company complies with Title 35, fines are rarely levied. And as far as training for users, both the company has a responsibility to train their users, and the cities that have ordinances have trainings available as well. So with that, Madam Chair, I'd like to turn it over to Captain Dan Nabel to offer some comment about Sandy Springs ordinance.
Thank you. Go ahead.
Good morning, Madam Chair, and I appreciate the opportunity this morning. Just as a brief introduction, it's clear we have this bill because there is such a problem with false alarms and the burden that it puts on cities and counties, police departments to answer these alarms. And not just the burden of the officers who answer the calls, but prior to us implementing the ordinances that we currently have, as many as 18% of all of the calls that were coming into the 911 center were false alarms. And that means that the person with the true emergency, a robbery or a crash with injuries or something like that, has to compete with these alarm companies for time to get their true emergency dispatch. The alarm company hasn't done anything to verify that there's really a true emergency. 99.5% of all the alarms in the city of Sandy Springs are false alarms. And so it's quite a burden for the city. But specifically to this bill, the bill says that the municipality cannot fine an alarm company for something that is not their fault. And the presumption is that the police officer who arrives at the scene of an alarm that's false has some means to determine whether or not it's the alarm company's fault for an improper installation or an improper vetting, or if it's the user's fault for improper operation. So it's an undue burden on the municipality to figure out who is responsible for this false alarm. If we don't allow municipalities to choose to fine alarm companies, we're holding alarm companies to a different standard than we're holding all of the other citizens who use the 911 system. We expect citizens who dial 911 to have made a reasonable effort to determine that there's really a need for police services. And if they abuse the system, then there's consequences, and those consequences can vary. But shouldn't we hold the alarm companies to the same standard and allow governments, if they choose to do so in an ordinance, to hold the alarm companies to the same standard as a citizen? And if they call, request 911, and they haven't done anything to vet whether it's a real emergency or not, then they should suffer the consequence if the local municipality chooses.
Thank you. Does anyone have a question for the officer? Thank you for your testimony. Let's see, I believe we have another speaker, Chris Balls, Brookhaven City Attorney.
Yes, ma'am. Madam Chair, thank you. And members of the committee, thank you for your time this morning. On behalf of Mayor John Ernst and Chief Gary Yandura and Deputy Chief Brandon Gurley, good morning from Brookhaven. I've been asked to fill in because Chief Yandura and Deputy Chief Gurley have other duties that require their attendance, but they did both want me to give their regards to the committee and to Representative Gullett. Brookhaven passed this ordinance in 2017. The members of the committee who've been around the legislature will recall that Brookhaven's only 8 years old. We began operations in December of 2012 after a successful referendum authorized by the General Assembly. In 2015, 16, and 17, Brookhaven had almost 4,000 false alarm calls that police were required to respond to. That's over $200,000 of police time spent on calls that were incorrect and inappropriate. There's been a dramatic decrease in false alarms since we started enforcing this ordinance. The ordinance was passed just after Thanksgiving in 2017. It did not go into effect until January 1st, 2018, in order to allow the alarm companies to have time to adjust to the new regulatory reality. We then placed enforcement on hold while the alarm companies in Sandy Springs went to court. And then once the 11th Circuit affirmed the judgment in favor of Sandy Springs, we began active enforcement. And then between 2017, before the ordinance went into effect, we had 3,654 false alarms. In 2020, we had 1,798. That's saving the city of Brookhaven over $100,000 a year in police time responding to these particular false alarms. The number that keeps being bandied about by Mr. Loud and Representative Gullett is something in the order of $400 per offense, and that's just flatly not true in Brookhaven. In Brookhaven, the first two alarms do not result in any penalty whatsoever. The third and fourth alarm have a penalty of only $50 per event, and it goes up from there until you get to the seventh offense, and then there's a $500 penalty because we obviously haven't gotten somebody's attention to correct their misbehavior. The City Council in Brookhaven made the policy choice of placing this obligation on the company and not the customer, because the company has a duty and obligation to train, inform, and maintain their systems. They have a duty to, we believe, to train their customer on how the system works, to inform the customer when there's a problem that needs to be addressed, and then to maintain the system so that it operates appropriately. It seems incongruous to the city leaders in Brookhaven that in an era where the legislature is contending with repeated calls to defund the police, to restrict police resources by giving private companies a pass, where they are apparently not complying with the code that this body has already enacted, and to further restrict police resources to respond to calls for help by requiring officers to respond to false alarms. This is a policy choice at the local level. It does not endanger public safety. In fact, it enhances public safety by releasing police resources to respond to actual calls and actual emergencies as opposed to false alarms. I appreciate the committee's time this morning, and I'm happy to answer any questions from the committee.
Thank you. Let's see. Representative Williams.
Thank you, Madam Chair. Thank you, sir, for your testimony. Do you have the name of the alarm companies that you've had the most problem out of, or are you allowed to give that out, or is it one certain company, or is it a mixture of different companies?
Representative, it's a mixture of different companies, as I understand it. The truth of the matter is that Brookhaven's not made a single dime on this program. We have not enforced the penalty, as far as I'm aware, against any company. There is an appeals process in our code. There's an officer designated in the police department to address concerns where companies either object or don't want to pay. And in most instances, the company has been able to come in and say that they complied with 3519, and we have not assessed the penalties against that company. So what we've been able to accomplish by holding the company responsible is to make sure that they're doing what this body has said that they're supposed to do. But no, sir, the direct answer to your question is I do not have the data on where the problems are, if it's a single company or multiple companies. I do not believe, well, I don't know whether we've had any companies say they're not doing business in Brookhaven anymore. I don't have that data or haven't been provided that information.
Thank you. Representative Roberts, did you have a question?
I have a question for the
author of the bill?
Yes.
Okay, go right ahead.
I'm number 10.
Yeah,
Am I on now? Okay, sorry. I know that my alarm company, I have a credit card on file and it charges me every month. So is there not some ability for y'all to put in your contracts that if you are fined because of some error on your customer, that you can't just charge a credit card and they know that that is a penalty they're going to absorb?
So I will argue, I do believe that probably could be in the contract. But as a company who charges $20 a month in a field that has many different competitors, I think at the end of the day, these alarm companies are going against good business practices at the end, just because I have such a broad number of alarm companies I could potentially use. All of a sudden you find me $250, I can go shop somewhere else. And so at the end of the day, it's the principle that can maybe work, but the principle of the item is, I think really to what Mr. Lau spoke to, is we're not finding Hardy Chevrolet in my district when there's a speeder. And And I know Brookhaven, I don't think they can speak, or Sandy Springs can speak to ever finding a dealership for a speeder in their district along 285 or 85. And it's a principle of it's the customer who's having the problem. And if it's not, the alarm company is going to pay. If I install the alarm, if the alarm system installs it incorrectly, then they're going to pay. And to the point, I'm not sure if I answered your question. I'll let you answer some
I
more.
guess if you push it through to the customer and the city has to collect,
Sure.
that's much more challenging because they don't have a credit card on file that they can charge. And so
It's a lot.
I understand the F-150 argument, but there are other arguments the other direction. If I walk into a restaurant with bare feet and I cause some uncleanliness, the restaurant's going to get the violation, not me for not enforcing the rules, right? When they get their health checkup, their whatever you know what I'm trying to say. So you could find examples of both things, but you're in the best position to impose a fine on the bad actor because you have a contract and a credit card. That's where I'm seeing it.
Yeah, I hear your point. I don't think that's a valid one, especially around the feet in the restaurant issue, just because one, we have a relationship. Here's the relationship. You're responsible for what you do. I don't have a relationship with a customer walking in until they actually buy something. And if I sell something to that customer, then I have a problem. They walk into my restaurant, cause some uncleanliness. There's nothing you can do. I have a relationship with this company. This is absolutely the user's responsibility. And so what the end result of all of this is that alarm companies are going to leave these places. Alarm company, Sandy Springs Chick-fil-A didn't have alarm service for 2 months because there's a no dispatch. So it can whir all day on Sunday when there's no one in there, but someone's taking all the Chick-fil-A sandwiches. Police have no idea and they don't care because they haven't been, they might care, but they haven't been notified. So there is a problem.
Sandy Springs and I know they care. We have a great police force.
I understand, but there, and I love my police too. And Brookhaven had Yandura. He came from Hiram, and same with Gurley. He's from Paulding County, my area. He's actually a constituent of mine. But this is a consumer problem. They are the ones who are responsible for this. Having alarm companies, principally in my mind, responsible for false alarms. It's just encouraging alarm companies to get out of the business and to just say, hey, we're going to have a no dispatch. We'll give you the sounds all day, but we're not going to dispatch because we're not going to take that liability. And that's a public safety issue.
Thank you. Chairman Powell.
Thank you, Madam. Thank you, Madam Chair. I want to ask a couple of questions, not just to the author, but to the gentleman that's testifying over here. Could you tell me that how the municipalities and the local governments, when there's false alarms, do y'all have any idea how many are operator error as opposed to the installation error or the companies? Have y'all gone that far as to determine that? Yeah, I'm talking to you.
Oh, I'm sorry, Mr. Chairman. I didn't realize you were asking me that question. Please forgive me for misunderstanding.
All right.
We have not inquired in that. The reason that the policymakers in Brookhaven made this policy choice, and Mr. Loud and his organizations lobbied my council as much as they are lobbying this body for the change in the law. But they made this policy choice for the simple reason that the alarm companies in the city council's judgment have a duty to train and inform their users. If there's a problem here, then the alarm company needs to be the one to fix it. The alarm company is the one making the call to 911. The alarm company is the one that's administering their program. The alarm company is the one with the contract to make the calls. And it seemed to my elected officials that the appropriate place to hold people responsible and get this problem fixed was with the alarm companies. And the data from my police department bears out that actually has occurred. If I can expand my answer just briefly, Mr. Chairman, the answer I would suggest that the analogy offered by Representative Gullett and by Mr. Loud is simply not true. If I'm driving my car down the road and I'm stop for speeding, I'm solely responsible for that offense and that behavior. In this particular circumstance, when we talk about alarm companies and false alarms, there is joint action here. There is two parts to this problem. The first part is maybe operator error and the customer's problem, but the second problem is that we're not getting sufficient and adequate compliance with 3519. And those two things taken together create both a joint responsibility and frankly a joint liability that is ultimately between the customer and the company to resolve. Representative Roberts' questions were appropriate with respect to how this gets done, and our early response penalties, which are not fines, there's not a criminal sanction as part of this, so the language needs to be refined as well. There's not a fine here, there's a civil penalty, and the first two offenses have no penalty. We're just trying to get people's attention. The second two offenses, third and fourth time the same alarm goes off in the same location with a false alarm, the penalty is $25 for each offense. If we haven't gotten your attention by the fourth false alarm that you need to work with your customer to figure out what the problem is, I don't know what else we're supposed to do. Getting the customer's attention or these fanciful numbers of $400 or $500, which just don't exist in Brookhaven, have never been collected in Brookhaven, are just trying to scare people into finding that there's a problem where there frankly is not one. But Brookhaven is trying to address its own public safety choices and its own response to calls, which have in fact worked by reducing false alarms by half in only 2 years.
Further question, if I might. So I'm trying to get the feel of this. So it appears to me that when there are false alarms that go off, and I understand the aggravation to the public safety arena on that, but because they don't have a venue basically to find the consumer, if it's a consumer issue, then they're finding the company that has the contract or the venue to the city. So it looks to me like in a lot of these cases that the companies that are providing the service, they're having to basically bear the burden of the fine because of the actions of the consumer. Would it not be easier just to cut that consumer off if they don't, and I'm not a technology person. My burglar alarm is a 6 hour, but I'm not a technology person, and I know there's a lot of other folks that aren't either. So, I go to a friend of mine's house occasionally, and I've got the code, but I'm not quite sure what I'm doing when I push the code. And if I set that alarm off, then these other folks are going to get the burden. So I guess maybe the burden to me, I'm trying to think that maybe the burden needs to be on the culprit. And if the company has signed a contract and once they've shown folks that burden needs to be on the ones that's actually, making the error. And if it's a repeated error, then maybe they just need to be cut off of the system. And that way, if they want to go to another company, then so be it. But the companies, I can understand that a lot of these companies are bearing an awful lot of expense, but the burden should be on the consumer themselves, I would think.
Thank you, Mr. Chairman. We are lit up like a Christmas tree. Okay, Representative.
I have a way of doing that.
Roberts, please go right ahead.
Okay, so I have a question for Mr. Loud. You referenced that Cobb County had done the study and had implemented a model and that it had dramatically reduced the number of false alarms. How is that different from what Sandy Springs and Brookhaven are doing?
So great question. Thank you for asking. So when Sandy Springs was actually created as a city, Georgia Association Chiefs of Police, the alarm industry with the model went in and met with them and developed this exact same model ordinance that was adopted statewide back in 2004-ish. And they began that process, same one that Cobb County did. The unique part is when they started, and this again, if we can understand, this is not about a Sandy Springs or Brookhaven. This is a much larger business discussion that's going on, but just to deal with the specifics, since all of us are here.
It
to
is
talk
my
about
city, so
Okay.
yeah.
So that model ordinance that was done was used and managed by a company called CryWolf. CryWolf is the software outside agency that Cobb County uses, City of Atlanta uses, Dunwoody, the list goes on. Most agencies use an outside source that manages it, so it's not an internal burden. So there's not that cost factor. They're the ones that typically, on behalf of the jurisdiction, are finding the subscriber, the business or the homeowner. And to the point that was made is that when a city is sending a fine, as opposed to a company, to the mention he did, quickly, they're going to pay attention to when the city is sending a citation, as opposed to some outside vendor that they can quickly change to another provider. But that, back to your question, that same model ordinance that was used, when we went back in to visit with Sandy Springs, we showed them 5 specific areas of that model that they never enacted. So enhanced call verification, which was discussed, that Representative Tom Taylor worked closely with our industry. We came before your body and asked them to see about having enhanced call verification. And what that code was that the attorney from Brookhaven was referencing is that we wanted to tell our subscribers, we want to make 2 calls before we dispatch because we don't want to waste police resources. I'm a taxpayer before I'm a business owner. So at the end of the day, I'm looking out for my tax resources also to say, how do we reduce that? But it is the exact same model. And if they had followed a lot of the others, they would have had significant decreases. The request of Sandy Springs chief and mayor and city manager at the time, they wanted to go to 0 false dispatches. Sadly, in our industry, because there's human errors and mistakes that happen, or there's a balloon or a plant, an alarm activation will occur. And if somebody is unsure that they had a party the night before and left a balloon and it does cause a dispatch, that they don't cancel. That is so beyond our control. But by contract, we have made the 2 calls and you have not chosen to cancel with us. We still by contract have to cancel. And to address the credit card question, if I may, for a quick minute, most every company has a similar agreement with their end users, and it does have in there, if there are any fines, that we can actually go to you to pay that. So it's already in the contract. The difficulty becomes when they transfer, again, we have that $20 fine, but we have a $250, and in some cases, truly, it's a $500 fine. They switch. They're not going to be beholden to us. So we're actually not helping to reduce the dispatch situation when they can go from company to company.
But can't you charge it instantly and get your money before they transfer?
And you've probably heard of a chargeback. Yes.
Gotcha.
Yeah. And that's the, they can be like, well, I'm not with that company anymore. And they, and it's a 30, 60-day process that you're with the credit card company. And the amount of process, and this is why many companies are not even choosing to do business in certain jurisdictions, because the amount of process for us as a company to be able to deal with the administrative process to keep in compliance so we can have dispatches is so burdensome that there's just not enough there and there's enough elsewhere. But the difficulty becomes if this now becomes something so spread wide or in other types of businesses, that becomes a big concern.
If you don't mind, I have, you've been very patient, Representative Sands. You've been waiting a long time. If you'll ask your question, and then we are going to move on. We have 2 more bills to cover. Representative Sands.
Thank you, Madam Chair. And I will be quick because I think most of it has been answered. But in terms of the ability of the companies to charge, which I already see a possible issue with if the contract's already been written for it to be revised. But would anyone speak to the fact that if we're going to place the responsibility between the user and the government of imposing burden on the government for that false call, could the company not make the fine $100 fine to say they're paying for processing and at that point give the customer an unfair or a larger fee than just having handled it directly with the city? Is that something you found the alarm companies would possibly do that would create a less uniform standard there?
If I'm understanding the question, since there is this processing cost, if I have a fine of $250, could I actually assess an additional $100 for processing? Is that what you're?
Yeah. Yes, and I'm guessing you would not do that because you seem like a fair and reputable company. But could a company not just decide, well, if we're going to have to do business here, we're going to double the fine anytime the government, the city puts it on us?
The answer is yes, but however, you're back to the same collection issue in that case. And there are some that are doing $25 processing fines. They are actually doing that. And I think I would submit before the committee that at the end of the day, this is something that we will share other police chiefs that will come in and tell you that alarms, albeit that there are some false elements to it, okay? Alarm industry is something inherently good for the overall community policing response. That when you have alarm systems around, and let's use Sandy Springs, we're looking at, if there's a dispatch that occurs somewhere and there was just a break-in, they're gonna have a greater idea to be able to know where that burglar possibly could be in the area and to the next place, to the next business, or the next home. Whereas if all of a sudden there are no dispatch or there are nothing like that, for them to be able to actually find that. And just like when Sandy Springs came out with their ordinance, it really told folks, hey, there's non-dispatch going on. If you're gonna actually go break in somewhere, that's where you wanna go. Inherently, I think a bill like this would be good for the consumer because it puts the responsibility, just like the shutoff, if they don't maintain it or educate or pay their fines, there's non-dispatch, and where it's bad for business. So
thank you. And Madam Chair, when it's appropriate, I'd like to make a motion.
Just one moment.
Okay.
We have one more speaker. Chief Desmore, you got 1 minute. We got more bills, so you've got 1 minute if you're still there.
Yes, ma'am. Madam Chairman and committee. Ken D. Simone, Police Chief of Sandy Springs. Real quick, this is not a false alarm issue. This is false calls into the 911 center. 99.5% of all 911 calls coming into our call center from alarm companies are false. That's the main problem. Mr. Loud, his Ford is broken down in Sandy Springs and he's calling the police department to fix it for him. That's what's going on. So he mentioned Cry Wolf. The reason we have to have a company named Cry Wolf to manage all the false alarms is like the fable. Once you cry wolf so many times, nobody comes. And I think that's where we are right now. We have verified response. What he just said about the police not going is absolutely false. With verified response, when we see or get a dispatch of a break-in, we know somebody is there. So actually, the number of break-ins in Sandy Springs, since we implemented our ordinance, went down, but the number of people caught in the act has gone up 300%.
Thank you very much. We appreciate your sharing with us. Okay, at this time, Representative Sands, you had a comment?
To make a motion if appropriate.
This is the appropriate time.
To pass House Bill 464.
Do we got a second? All those in favor say aye. Oh, excuse me. Okay.
House Bill 465.
He corrected the number.
Apologize.
Okay, thank you. All those in favor say aye. Aye. Those opposed? We have one. Okay. Any online?
Shane's aye.
Okay, the motion passes. You're on to full committee Monday. Thank you. We have Bill 148, if you'll come forward. Representative Schofield, there you are. Thank you. The mic is yours.
All right. Good morning, Madam Chair, members of the subcommittee. I bring before you House Bill 148. This is really a simple bill. This bill was first introduced in the 2019 legislative session as HB 34. But during the 2020 session, it passed favorably by substitute out of committee. Unfortunately, due to COVID, it didn't make it to the House floor for a vote. HB 146 is the exact same language as the HB 34. This bill was originally carried by Representative Valencia Stovall, and by the way, she says hello to everybody. Says she misses you all. But I understand, Madam Chair, you had some concerns. And so these are some concerns were addressed in the sub LC 478099S. With that being said, GMA supports this bill. We have the mayor of Norcross and other mayors that are supporting this bill. Again, it was a bill that didn't make it to the floor because of the COVID, and it passed out of the subcommittee. I ask for your consideration.
Do we have anyone on the committee that would like to speak? Please, what is your number? Thank you, Representative Maynard.
Good morning, Representative Schofield.
Good morning.
I have a question. One, just because my background is doing things in ethics, and since part of your bill talks about removing someone due to ethical violations, right now, currently, counties and municipalities, they have their own ethics review board. And so there are things that have to happen based on current county and city regulations for ethics review. Now, I do see in here, you have one portion of here that talks about the person in question being notified, but there's a whole nother section that's not in here that is pertaining to how someone even can file an ethics complaint. And all of that kind of information would be in the county and municipality ethics review.
Yeah, so I'm just gonna, could you just tell me what your question is? I just wanna make sure I'm understanding.
So the question is, it seems like this is not a complete bill because it's missing a portion. You can't just talk about one end of an ethics complaint and not the front end of the ethics complaint. And I only bring that up because it outlines that in here.
Okay. Well, I will thank you for that, and I will take a consideration and look at it again. I know this bill passed out the first time. I'm carrying it as a continuation of Representative Stovall, so I'll look at that when I get an opportunity.
Thank you.
Thank you.
Representative Brunel.
Yes, thank you. Can lead counsel answer her question about, she says that we left the part out of the bill, since I was one of the signers on the bill the last time and currently.
Legislative Council, do you have that info? Number 5, go right ahead.
Reading over this provision, it seems to be in line with some of the other general provisions in existing state law about like downtown development authorities. And I mean, it seems in line with what's already on the books in other set parts of the OCGA.
Thank you.
Thank you. At this time, the chair actually has a couple questions, and it has to do with your section 1. It's adding directors that are not residents within the county or the municipality to the development authority. That's the first part of it. I will tell you, we had this discussion in our community, and there was a lot of pushback that somebody that just has a financial investment is making determinations for the residents that actually live in the community. So I think this is a little deeper. At this time, we're just going to hear this today, and I'd like to call this back up, and we may need some clarification.
Sure.
Thank
sure.
you
and
very
remember,
much.
it's always an option. That's
Thank you.
what's-
Thank you. I appreciate that.
Thank you so much.
Thank you. And we have one more bill, House Bill 608. If you'd come forward, Representative Wiedenauer.
Morning, Madam Chairman. Bringing to you House Bill 608 LC, working off of LC 364723S. And with that LC, I'm going to give a little shout out to Ledge Council. They are the unsung heroes of all the stuff we do down here, but they've been working hard on trying to tweak this thing as we get it better and better. This is a bill, a bit of a unicorn where, quite frankly, the telecoms, the EMCs, and the cable companies are all working together trying to find a good solution. We feel like this is a great one to continue our efforts of expanding broadband across the state of Georgia. That is the intent and the function of this bill. All of those members are here to talk to it if you guys have questions for any of them. One of the biggest things in this bill is the definition of unserved location. We got into the way it's currently worded using census blocks and unserved areas. Some gaps occur. And this would allow for us to, if somebody has a project that's already been funded, but they expand that project to hit areas that got overlooked or are missing or falling into the gap, that we are able to, we're opening up the toolbox for them to have opportunities to get funding to serve those areas as well. That is the general gist of this bill. I'm going to be brief since we're short on time, but certainly here to answer any questions.
Do we have any questions for the author of the bill? Representative Williams.
Thank you. At the proper time, I'd like to make a motion.
Okay, do we have any further discussion? This is the appropriate time.
Make a motion to pass.
Any discussion? Do I have a second?
Same second.
Okay, any further discussion? All those in favor say aye.
Aye.
Any opposed? Your measure passes. You're on to full committee Monday.
Thank you, ma'am.
Thank you very much. I appreciate everyone being here, and we are adjourned.